Welcome back to the Texas A&M Agriculture Law YouTube channel. I'm Tiffany Lashman. If you've been following the agriculture news lately, certainly you know the topic of the hour is dicamba. And we recently published a blog post on our Texas Agriculture Law blog, giving you the rundown on exactly what's going on with the dicamba situation in the United States. What happened back on February 6th is that a district court in Arizona actually vacated the federally approved labels for 3 over-the-top dicamba products: XtendiMax, Ingenia, and Tavium. And for those of you that think this sounds familiar, yes, something very similar happened in 2020. Back in 2020, it was the United States Court of Appeals for the Ninth Circuit that vacated the 2018 registration for over-the-top dicamba products. Registration was then reissued in 2020 for these 3 products we're dealing with today. And now here we are in February of 2024, and that registration has also been vacated by a court. We've got the full rundown on the opinion on our blog. We'll link to that in the show notes below. Big takeaway here is that basically the court says that the EPA violated FIFRA, which is the federal law governing pesticides, by failing to have notice and comment on its new registration for these dicamba products. The EPA had taken a position that it really wasn't new registration, and so they didn't have to conduct notice and comment. The Arizona federal court disagreed. And so that happened on February the 6th, and that left producers kind of scrambling to figure out what their options might be for this growing season. On Valentine's Day, the EPA issued what they call an existing stocks order, had a similar order issued when this happened in 2020. And what that says is essentially that for existing stocks of these 3 pesticides, they can still be used at least through part of the growing season this year. An existing stock of a pesticide is defined as those stocks that are currently in the United States and were packaged, labeled, and released for shipment before February 6, 2024. All right, and so what does it mean to be released for shipment? That is when the product has been packaged and labeled by the producer and in the manner in which it will be distributed or sold in, or has been stored in an area where finished products are usually held for shipment. So the existing stocks order does put some limitations on when these products can be used by. Those differ a little bit by state. So check that order to see your specific state. For those of you watching in Texas, existing stocks may be sold or distributed for soybeans through May 31st, and then can be used on soybeans by June the 30th. Okay, deadline's a little bit more extended for cotton. Cotton, they can be sold or distributed through June the 30th and must be used by July 30th. So what happens next? That's a question we've been getting a lot, and the answer, we don't exactly know. So several moving pieces still in this litigation. First thing to keep in mind is that the EPA or Bayer who intervened in the lawsuit, either of those parties could appeal this district court decision to the United States Court of Appeals for the Ninth Circuit. That is certainly still on the table. Do note that the Ninth Circuit previously vacated the registration in 2020. Obviously, this is a different registration, different facts before the court, but I do think that's something that's important to keep in mind. Second possible option is the plaintiffs, right? The environmental group who filed the lawsuit could challenge the existing stocks order, right? They may not be pleased with this existing stocks order that's going to let this product continue to be used. They could seek some sort of an injunction or something to prevent that use of existing stocks. Third, we don't know what will happen in the future as far as will the manufacturers seek to re-register these 3 products again and provide additional notice and have the EPA go through the process and include that notice and comment rulemaking. And then if they do file those applications, will the EPA then approve them, right, or register these products again? So lots of uncertainty, at least for now. You know that you're going to have access to these products through the 2024 growing season, at least with those dates we mentioned. And again, those differ a little bit by state. But that's where we are currently with dicamba. If you want to read our entire blog post that goes into much more detail on this, again, we'll link in the show notes below. Thank you for following along here on the Texas Agriculture Law blog. We'll be back next week with more information.